Morning, Ms. Hayden, good morning.
Good morning. May it please the Court, my name is Jennifer Hayden. I'm here on behalf of the appellee, Pamela Carter. With me today is co-counsel on the case, James Breslauer. Pamela Carter is here today to ask that this Court affirm the motion judge's decision restoring her Section 8 subsidy. In the alternative, Ms. Carter asks that this Court remand this case to the Housing Authority for a new hearing with specific guidance to the hearing officer. This guidance should provide instructions that require the hearing officer to demonstrate in his written decision that he understands, explains to the parties, and exercises his discretion in coming to a conclusion about the termination, and includes facts upon which the decision is based, including credibility determinations of the witnesses. My argument is twofold. The hearing officer's decision is incorrect as a matter of law, and the regulatory scheme that requires that individual circumstances be considered was not followed.
Who has the burden of proof in the original proceeding, in the hearing?
The standard is preponderance of the evidence. I believe that it's difficult to tell. I believe that the Housing Authority must prove, beyond a preponderance of the evidence, that the tenant has indeed violated.
And does the tenant have the responsibility to put forth mitigating factors?
Tenant has a responsibility to bring evidence. She's instructed to bring evidence. However, there is, I believe, a duty to assist on the hearing officer's part, as there is in other analogous case scenarios, such as welfare, workers' compensation.
There's nothing in the regulations that would require the hearing officer to assist, though, is there?
There's nothing in the hearing regulations that requires the hearing officer to assist per se. However, I would argue that in other cases where a significant interest, such as a property interest in this case, is at stake, that there is a duty on the part of the hearing officer to elicit testimony.
Do the welfare regulations suggest that the hearing officer has to help out the applicant?
Certainly in welfare, certainly in unemployment.
What about
situations.
here?
I'm sorry?
What about here?
It's not clear. There's nothing on point that suggests that. But again, the hearing officer is in the best position here to assist someone.
What significance do you place on that small claims judgment in which the tenant was required to pay the landlord, I think it was $1,400 for waste?
I think it's significant in that there was a judgment against her. However, what I think is missing is a consideration of the mitigating factors with regard to that decision. At the hearing, that judgment from the small claims court was presented. However, there was nothing in the record, or it's not clear from the record, if my client, Ms. Carter, talked about the animosity between the parties. Prior to the small claims action, my client had signed an agreement for judgment the year before in which the landlord had to return over $1,000 to her for a security deposit that wasn't held correctly and for illegal fees that he had collected under the Section 8 program.
But doesn't it follow that if there was a judgment against the tenant, that the tenant was responsible for the damage that was done?
I'm not disputing that my client was found by the small claims magistrate to be liable for that damage. But what I will note is that the trial judge, Justice Ireland, noted that my client, there was no indication that my client had committed active waste or malicious destruction of property.
I was trying to figure out if there was a conflict between the agreement to return the security deposit and the small claims judgment. I take it that there's one way to resolve the conflict, and that is to say that the agreement to return the security deposit, which you would otherwise hold and apply towards damage, was returned before any damage supposedly occurred, and that the small claims judgment covered something that occurred after the agreement for the judgment that included the return of the security deposit. Is that the best way to look at this?
I believe it is because of the language in the agreement for judgment, which says that that this agreement waives all claims
Yeah.
arising from the tenancy.
But you don't, I know this is really not part of the case, but do you have any idea when that videotape was made?
I don't know when it was made, but I'll suggest to you that the small claims case was filed 3 months after my
Right,
client
that's
left
what
that
I
apartment.
was,
So it's,
and that was part of what it appears she brought up in the housing, that there had been this gap in time.
absolutely. And it's concerning. And that tape actually wasn't at the hearing, or if it was, we don't have any indication
At
of that.
which hearing?
At the Housing Authority hearing. It's not clear. Most troubling about this case is the insufficiency of the record.
Was the tape played at the small claims hearing?
Yes, it was.
Okay.
Yes, it was.
And was
Without
that-
sound and on a very poor quality machine.
Was she represented by counsel?
At the small claims hearing? No, she was not.
Was
Was there an
she,
objection to the introduction of the evidence of the tape?
I'm not aware of that.
Yeah, are small claims hearings governed by the rules of evidence?
No.
No,
It's
they're
it's
not.
a relaxed view.
Right. That's my understanding as well.
They're
Was
very
there any
informal.
attempt to establish when the videotape was made?
Not that I'm aware of.
So we don't know.
We don't know. Very troubling.
Do small claims judgments have preclusive, are they considered res judicata?
I believe so.
There's no reason, okay, yeah, nobody's arguing that they don't.
No.
Can I ask you something about the regulations, if I could?
Absolutely.
In 982.552 C2 4, I'll get there. If a family includes a person with disabilities, the PHA decision concerning such action is subject to consideration of reasonable accommodation. And nobody talks about that. Did that come into play here? Because, at least from your perspective, this was a person with disabilities.
Yes, my client is disabled. I don't believe, or at least it's not clear from the decision, if a reasonable accommodation argument was raised at the hearing. If it had been, the regulations certainly require that it be considered. It
But
would
I mean,
not-
it hasn't been raised on appeal either.
No, no.
So you're not making anything out of that.
Not out of reasonable accommodation. What we suggest about the disability is that it is a mitigating factor, which would have impeded Ms. Carter's ability, and will impede her ability, to find or access new housing, or potentially housing at market rent, due to the stigma of being a disabled person, due to the difficulty in perhaps negotiating a new contract. The individual circumstances that should have been considered in a Section 8 termination hearing are delineated in the code. What we know is that Ms. Carter attended this hearing pro se on May in 2003. She brought with her 2 witnesses and 2 pieces of evidence. We don't know what her witnesses said or when they saw her apartment, although their testimony suggests that they saw her apartment, but we don't know when. We don't know how her evidence was weighed by the hearing officer in this instance. We also know that they signed this agreement for judgment and that the return of the $1,005 to Ms. Carter very certainly created animosity between the parties. That's certainly a mitigating circumstance that the hearing officer should have been aware of. It's not clear if he was, though. We know that under the same agreement, Ms. Carter was to vacate the premises, and she did. We know that the small claims action was filed almost 3 months afterwards, after she moved, excuse me.
Let me ask you a question. You said about something that we don't know if the small claims officer was aware of the animosity between the tenant and the landlord. But who was evidence presented on that issue?
I believe that the small claims judgment was presented to the
Right,
hearing
I
officer.
understand that, but the issue that it may have created animosity, was that made before was that argument made or raised at all before the hearing officer?
I wish that I could answer that, Justice Cowan, but the record from the hearing officer is unclear on that point.
But isn't it an inference that can be drawn from the evidence that was presented?
An inference that can be drawn that
That there was animosity?
I'm not certain about that.
Well, it's not even clear that the prior judgment. You're saying that the return of the security deposit, that judgment, which came out of an action that the landlord brought, right?
Yes.
Created animosity which may have fueled a landlord's attempt to collect damages for waste. In other words, file the small claims proceeding, right?
Correct.
All right. Well, there's certainly nothing of that in the record, such as it is. So I assume, I think you have to assume that that was not raised by the tenant at the hearing.
It may not have been raised. However, it's my understanding that Ms. Carter brought with her a copy of the agreement for judgment as part of her documentary evidence, which was supplied to this court as a supplement. The agreement for judgment would have suggested, clearly indicated to the hearing officer that there was money passed between these two parties. And I think there is an inference that can be drawn, but I'm not clear from the Housing Authority hearing officer's decision if that was considered. It may well have been, but what we have is a decision that says, this is what happened at the hearing, we're terminating.
Are you saying that a hearing officer has to go through every bit of evidence and say, here's the possible inference that could be drawn and I didn't draw it?
What I'm suggesting, Justice Spina, is that under the regulations, this type of hearing is mandatory. After that, there are mitigating circumstances that may be considered. And it's our position that those mitigating circumstances were not considered, or at least are not reflected in the hearing. As far as the hearing officer having to go through every piece of evidence, I believe that it's certainly important to go through the evidence that speaks to coming to a conclusion about a termination. As I said, I don't believe that there's any middle part in the analysis of this case, in the analysis by the hearing officer, and that is what a reviewing court would look at.
But couldn't the hearing officer rely almost exclusively on, if not exclusively, on the small claims judgment for damage?
I don't believe so.
Why not?
Because in this situation, the Housing Authority is required to offer, they're mandated to offer a hearing wherein individual circumstances must be considered. Following that in the regulations.
But you mean the mitigation circumstances have to be considered?
Individual circumstances.
Okay. So isn't it incumbent upon the tenant at that hearing to present the evidence?
About her circumstances.
I think that there's a problem with that, because what we have here is a pro se litigant at a very important hearing, whether it be informal or not, who is sitting here in front of a Housing Authority hearing officer, vying for her public housing benefits, who has not been told what mitigating circumstances she may bring to the attention of the hearing officer. And it's the hearing officer's in the best position to inquire about this. He doesn't have to do an extensive inquiry, but he could certainly say, is there anything else that you could tell me that might influence my decision? I don't think that that's an onerous task.
Ms. Hayden, what do you make in the particular part of the regulation that you are referring to, which I take it is small I in this 552C, when it says may, and that is the PHA may consider all relevant? Do you think the hearing officer could say, I know I could, but I'm just choosing not to? Do you think the hearing officer could do that?
I don't. I think the hearing officer could say, I know that I am allowed to look at mitigating circumstances, but there aren't any. I think that's why the word may appears in the regulations, because there are situations in which there may not be mitigating circumstances to review, but there are certainly individual circumstances that must be reviewed.
And that comes from what? The individual circumstances must be reviewed.
That's under 24 CFR 982.555.
Okay.
That's the must. Must give an opportunity relating to individual circumstances.
There's a big difference there. There's a big difference between being given the opportunity to present individual circumstances as opposed to must consider individual circumstances. You're not saying, I take it here, that the tenant did not have the opportunity to present the circumstances.
I believe she had the opportunity.
You're saying that it's not clear from the record whether the hearing officer discharged his obligation to ask her questions about her mitigating circumstances.
Exactly. And it's not clear. The hearing officer may have inquired about these things.
But the regulation only talks about the opportunity.
The opportunity for a hearing. There's the PHA must give a participant an opportunity for an informal hearing to consider whether the Public Housing Authority decision relating to individual circumstances. They have to give a hearing about individual circumstances. They may consider mitigating circumstances.
But who would know better about mitigating circumstances than the tenant?
I think the tenant would know about mitigating circumstances, but I'm not convinced that a pro se litigant would know about the specific mitigating circumstances that might influence.
How about the tenant who's represented by counsel? Would you take a position that there's no requirement then for the hearing officer in that case to inquire into mitigating circumstances because they're not pro se? So for pro seers, the hearing officer inquires into mitigating circumstances, but for those who are represented by counsel, no inquiry?
I think that the hearing officer should deliver the same caveat.
Well, you're making the point, though, that they're pro seers. That's your major point. So I'm saying when they're not pro seers,
Counsel for the participant certainly is aware or should be aware of those things that would influence a hearing officer's decision. Yes.
Isn't your point, though, really that it's just not clear from this minimal decision whether the hearing officer even knew that he could look at individual circumstances, and if he could, that he did?
That's exactly right, Justice Botsford. As a matter of fact, this case was decided the same day as Wojcik versus the Lynn Housing Authority, the same housing authority, in the appellate court. And in that decision, counsel argued that, in fact, not only did the housing authority not have to look at mitigating circumstances, but they could impose the harshest sanction whenever they felt like it. So if we look at this time period, we could infer that the hearing officer at that time didn't even know he had discretion.
Thank you, Ms. Hayden. Good morning, Mr. Plimison.
Good morning, Madam Chief Justice, members of the court. May it please the court. My name is Webb Plimison. I appear this morning on behalf of the Appellant Lynn Housing Authority. We've been here before. I would like to stress that I agree with my sister counsel that one of the primary interests that the Housing Authority has in this case is to obtain some clarity on what I characterize as two general areas in the procedures that are before the court. The first area has to do with the communications between the Housing Authority and the communications between the Housing Authority and a participant against whom they intend to take some sanctioned actions for violations of program rules. And those communications take the form of, in this case and in many cases, there are two situations. One is there's a letter that is given to a program participant when the Housing Authority makes an initial decision to terminate. And the question is what is required to be in that letter. The housing.
Well, is that an issue in this case?
Well, it was an issue upon which the motion judge decided that summary judgment was appropriate for the tenant. He indicated that one of the defects in the Housing Authority's case was that both the letter from the initial letter from the decision maker to the tenant and this is the second communication, the written decision of the hearing officer in cases where a tenant or a program participant requests a hearing also didn't contain certain language. So we're very concerned about what is the obligation and what are supposed to be in these communications. We're being criticized. In fact, summary judgment was awarded against us in large part, according to the motion judge, because of the deficiencies in those communications. And we don't find any support in the regulations for the requirements that were imposed upon us and which formed the basis for the judges granting summary judgment against us and denying our motion.
Sure. I understand your need for clarity, but may I just ask you something else? You argue in your brief quite persuasively that the hearing officer's decision is unreviewable, right?
Yes, Your Honor.
Let us assume for one moment that we do not agree with you. whatever we may say about what the obligations are with respect to the letter of the decision maker, or that's a somewhat different, because we're not really reviewing that. We're reviewing the decision of the hearing officer. If there's nothing stated about whether the hearing officer knew that he could consider certain, that there was evidence but he rejects it, or that there was no evidence, what is a reviewing court supposed to be reviewing?
Well, I think the reviewing,
In other words, it may be your position that there's absolutely no judicial review, period, no matter what, in every single case.
Is that your position?
no. I argued that, and it's our position today, that the role of the reviewing court is to determine whether or not there were facts which support it, which would provide support for a hearing officer's decision that a violation of the program regulations occurred. If there were no facts, clearly the housing authority's decision would be completely arbitrary.
Yeah.
So initially, there has to be some, it would seem to me that a reviewing court has to find that there was some facts upon which a hearing officer could find a violation of the regulations. Secondly, whether or not the sanction imposed was within the range of sanctions permissible under the regulations. And finally, whether or not in the process there was procedural due process provided to the tenant.
And what are the facts in this case that you say support the hearing officer's conclusion?
Well, with respect to the issue of whether or not there was facts sufficient or sufficient evidence to support a finding that a violation occurred, the small claims judgment. I believe, as Justice Spina implied in his question, that the housing authority in this case can rely on the small claims judgment in which it was found that the tenant committed waste in excess of reasonable wear and tear.
If we had an indication that the hearing officer said, I have the discretion to consider mitigating factors, but I choose not to exercise it, we would have some guidance. Or if the hearing officer had said, in light of the seriousness of the judgment entered, I don't think there are any mitigating factors that can overcome it, or nothing has been presented to me about mitigating factors. We may have some way of knowing whether or not subsection, 1, I have to go way back to find out, what precedes it, but the one that says that the PHA may consider all relevant.
I'm not sure I understand your question.
Don't I have to know whether the hearing officer knew whether or not he could consider mitigating factors? Because essentially what you said to Justice Island, that here's a small claims judgment, that's it.
Well, I'm suggesting on the issue of whether or not there was substantial evidence to find a violation of the program, that's it.
Yeah.
Not on, and certainly we wouldn't require the hearing officer's decision to recite evidence relative to due process. I mean, the record sort of I assume that we wouldn't impose that upon a hearing officer that the written decision contain recitations about due process.
I'm not sure that I understand you.
Well, I'm addressing the three issues that I thought a reviewing court would be looking to, and I believe you're asking me whether or not the written decision needs to contain those things in order for the reviewing court to do its job.
No, I'm just looking at a regulation that said that the hearing officer may consider. I assume that you only get to considering the mitigating factors after there's been some violation, correct?
Yes.
So
you don't have a hearing unless there's a violation.
Right. So you have, and in this case, as I understand it, that's the small claims judgment. I mean, that's collapsing it, but that's essentially correct.
Yes.
Okay. So you get the small claims judgment, and then I have a regulation that says the hearing officer may consider all relevant.
I believe that the hearing officer's decision in this case reveals that the tenant offered none.
What do you point to that says that?
Well, he indicates that the evidence that was presented to him was from witnesses indicating that that she testified that she denied committing the waste, or that she or any member of her family denied the act itself, and that her witness testified in essence, and I don't mean to minimize this, that she was a good housekeeper.
So you're saying, I take it by implication, that the hearing officer laid out the pros and cons that were presented by each side, and the fact that there's no reference in there to mitigating circumstances is an indication that there was no evidence of mitigating circumstances.
Yes, Your Honor.
But
And
one
you can't expect, you can't
The
expect.
decision doesn't indicate a lot of things.
But Mr.
That's part of the problem in this case, and that's
But
part of the problem.
It also doesn't say that he doesn't find any evidence of mitigation. In other words,
That is
one
correct.
way to look at this is to say, one possible way to look at this is to say there appears to have been an assault on the underlying judgment in the small claims court. I mean, that's one way you could read his, and he's simply saying, I don't accept that that is sufficient to undercut that judgment. He doesn't say it in those words, but that would be a perfectly reasonable thing for a hearing officer to come in. In other words, if somebody came in and said, yes, I know I signed this agreement to judgment, but that shouldn't be considered a violation by me sufficient to terminate my Section 8 benefits because, not for mitigating factors, but because they've got the wrong party, or my lawyer told me if I didn't sign it, he would send, whatever it is. That seems to me is what the hearing officer perfectly reasonably is doing. But I can't glean from this record, I don't think, that he knew that he could consider mitigating circumstances. In other words, the fact that he doesn't refer to anything else doesn't answer the question, for me at least.
Well, I don't know how to respond to the fact that the decision doesn't reflect that he knew he could consider mitigating circumstances. Is that what you're asking?
Correct. In part.
I agree that the decision of the written decision of the hearing officer does not reflect that.
What if in fact, the hearing officer believed that in these circumstances he could not consider mitigating factors? So even if there's somebody who's visibly disabled, I'm not saying that that's sufficient, and he just thinks, I can't consider that, and is incorrect as to that, or doesn't know that he can consider mitigating factors. Again, if the court is not reviewing it, that issue doesn't arise. I'm just looking at what the regulations
Well, the
provide.
appeals court said that he's not obligated to, but that's a
Right.
But aren't
A
you
different
saying
set of
it's implicit that he did consider all that was presented to him and that there was no mitigation presented, thus he could find no mitigation?
yes.
That's your
And I
position.
think it's from that point, yes, Your Honor, and I think it's from that point that my sister argues that because of that, there's an obligation on the part of the hearing officer to go beyond and to make further inquiry, to take an active
Mr.
role in
Primuson?
seeking out mitigating circumstances, et cetera, which I think
Yeah,
is
Mr.
what they're-
Primuson, where do these hearings officers come from?
Well, the regulations in general indicate that the hearing officer can be anybody who's selected by the housing authority so long as they are not a direct supervisor of the original
Do we know
decision
anything
maker.
about this hearing officer?
He's an attorney who practices in the city of Lynn.
We do know he's an attorney.
Yes, the decision is written on his letterhead. That's how we know that.
And
Do we know whether or not he had read the regs?
The record doesn't reflect it. If you're asking me, do I know whether he's read the
I'm just
regulations?
asking.
He cites
Yes,
them
I
in his
do.
findings. Yeah, he cites them in his findings, the regs.
Yes, he does.
so, do
extensive.
these folks receive training?
They do. But it's not formal.
Well, what kind of training do they get?
Wait a minute.
I meet with the people on a regular basis, not frequently, but generally once a year, and make them and during the year I make them aware of cases that I think
There's
are
nothing in the
important.
record about this, though, right?
There is not.
Okay. Okay.
So the second area, the first area being the communications between the housing authority and the program participant in the form of both the letter of the of decision by the decision maker and the written decision. That's the first area. The second area is, of course, the scope of review. And on on this, I think, is where we get into some issues that are very important to the housing authority. The primary one is when and under what circumstances does the reviewing court overstep its bounds by substituting its judgment, his or her judgment, for that of the agency. And it seems clear to us in this case, when you analyze the motion judge's decision as to why he granted summary judgment for the tenant and denied summary judgment to the housing authority, that's exactly what he did. And he felt that the sanction was too harsh. And it's our position that that's not within
That's
the
not his
scope of
job.
his authority. That is, yes. Particularly given the following circumstances. This is a federal program with a limited amount of resources available to a housing authority, and the regulations which are contained in, or the Federal Register, in which HUD explained reasons for the regulation's existence, indicated that their intent was to provide to the housing authority the maximum amount of discretion. That is the intent of the program. Those are the regulations, the rules under which the program is administered by the Lynn Housing Authority and every housing authority, because it's not their money, and these are the rules by which they live. So given the fact that the intent of the program is to grant the housing authority the maximum amount of discretion, we feel that limits to a great extent the role of a reviewing court when a program participant who's been terminated seeks judicial review of the decision of a hearing officer.
Is Mrs. Carter or Ms. Carter, is the stay still in effect? Where is she still a Section 8 tenant or not?
Yes, the stay is still in effect.
Are you,
Whether
so,
it's
so
legally
if,
still in effect or not, but all parties are treating it as if the stay is still in effect. She is, I actually don't know where she lives, but I know that a subsidy is being paid as if she had never been terminated.
so is the reviewing court to determine, for example, whether there's been an abuse of discretion? And if so, is that abuse of discretion simply related to whether there was sufficient evidence?
I think the review ought to be limited to whether or not there was
Sufficient evidence?
whether or not there was due process, and whether or not the sanction that was imposed was within the realm or range of available sanctions for the violation. And in this case, we believe that all those were present, and therefore summary judgment should have been granted in our favor.
Well, it has to be broader than that, though, doesn't it? Because, I mean, what if there were evidence that the tenant had presented evidence of mitigation? I mean, if this were tape recorded, this proceeding were tape recorded, and there was evidence of mitigation, and the hearing officer said, well, I can't consider that.
Well, if he said I can't consider it, I would agree that that's an error of law.
Yeah, but we
If
don't
he said
know.
that I consider it and I reject it in this case, or in my discretion I find that the violation, that the sanction is still appropriate, then I don't think the court has the right. That's where we get into the situation where a reviewing court would be substituting its judgment for that of the hearing officer.
Does the tenant get a notice that includes a summary of the regulations before the hearing takes place? In other words, outlining what the issues are and what you can do at the hearing?
Not at the stage that we're referring to.
So
That
if
is, when...
Does he get it after?
the tenant,
No, before. No. At the time that a person is granted a voucher. In other words, there's an application for the program, and then they come to top of a waiting list, then they're reviewed and they're given the voucher. Materials are presented to a program participant then. And I honestly don't know whether or not there's a summary of all these rights, but I will admit to you, certainly if there were, I doubt that many program participants could understand it. We have regulations that are multiple regulations. So that's the time, Justice Mina. It's certainly not after. But the honest answer to your question is, of course, no, not at the time that the decision is made by a decision maker to terminate. There is not a summary provided at that point in time.
So we
but
don't-
there is a direction, there is a reference to the nearest legal services agency.
so we don't know whether or not tenant, represented or not represented by counsel, knows that they have an opportunity to present mitigating evidence.
We do not.
Okay. Thank you, Mr. Plimison.
Thank you, Your Honor.